Do you wish there was a kinder and gentler way to get through a divorce? One that didn't require you to fight over everything, to go to court, to have a stranger decide your future? Well, there is. It's called collaborative law or collaborative divorce. I really believe that it is the future of the way family law will go, but it's not right for every case. I was one of the first adopters of collaborative law here in Orlando and one of the founders of our collaborative law group of Central Florida. People very often ask me, well, how is it different? My spouse and I get along and we don't want to fight, so aren't we going to do this collaboratively anyhow? That's not exactly accurate. Collaborative law is a term of art, and there are two very important differences that you need to understand if you're going to go the collaborative route. The first is we engage in interest-based negotiations as opposed to positional bargaining. Most of us are used to positional bargaining because it's what we've always done. When you go to a car dealership and the sticker price on the car says $75,000, you might offer them $65,000. And the salesman comes back to you and says, well, I won't sell it for $65,000, but I will knock down $2,000 off the price. And then you say, well, I'll come up $2,000, but that's it. You buy homes that way. Any negotiation in the traditional manner happens like that. You're just chipping at the edges of the price until people get tired and strike a deal. Interest-based negotiations are more like labor management, collective bargaining agreements, or player-team negotiations in professional sports. And the reason is the parties need to strike a deal. They want to strike a deal. After all, labor needs jobs and management needs workers. Players need players and players need a team to work for. They're going to have an ongoing relationship, just as you and your soon-to-be ex-spouse will if you have children. So, what we try to do is find a commonality of interest. This is interest-based negotiations. That's the fundamental process that we go through, is identifying those common interests and trying to achieve them. So we take the divorce from being a zero-sum game into a win-win situation. The second, and sometimes troubling to some people, major difference is that if there is not an agreement reached as a result of the collaborative process, both parties have to go and hire new attorneys to go to court with and start all over again. While this might be a frightening and conceivably expensive process, it is really what makes the collaborative effort work. It locks the door so that both the lawyers and the clients are committed to getting this done. If you think this collaborative approach is right for you, do a consultation with an experienced attorney, one who's handled many collaborative cases, but has also litigated it enough to know reasonable outcomes. Not every case is a collaborative case. Find out if the process is right for you. Give us a call here. I'm sure we can help.